community and has been a frequent speaker at our meetings. So her title today is So What Do I Have to Worry About Now?, which unfortunately seems to be a way of life for being a practicing pathologist or a group manager. So with that, I'm going to turn this over to Jane and let her enlighten us all.
Thank you, Bob. I appreciate it. What I'm going to do today is touch upon a variety of topics that we see a lot of our pathology clients facing. And certainly if you have questions, as Bob said, feel free to type them in, or I'll leave some time at the end for question and answer. And certainly at the end, if you have questions unrelated to anything I spoke about, feel free to ask them, and I'll certainly try to answer them. First item I wanted to mention, it's a brand new advisory, actually it's a special fraud alert that came out from the Office of the Inspector General today. Brand new on the OIG's website. It's entitled Laboratory Payments to Referring Physicians. And what this fraud alert describes are two situations which are increasing. I see increasing quite a bit in frequency, more dealing with clinical laboratories and molecular labs than they are with anatomic pathology labs. We do see some in anatomic pathology. The first is the payment of collection fees to physicians. Increasingly, physicians are requesting, or laboratories may be marketing their services to physicians, saying, if you send us work, we recognize it takes time on your end and your staff for the collection, be it a urine, blood, cheek swab. I've even seen it with anatomic pathology biopsies, for the packaging of that. Things that we would all assume physician offices have done for years without any payment. And laboratories are either marketing to get the business, advertising that these payments will be made on a per test basis, or we see physicians requesting it. I recognize in California that there is guidance that is, has been around for quite a while from administrative agency explaining that paying such fees would be problematic under your state fraud and abuse laws as a potential kickback with physicians. Nevertheless, I have even heard of in California that there are laboratories that pay these collection fees, and I'm increasingly hearing, even in California, of physicians who are requesting these collection fees. It's also important because if I look on the other coast in New Jersey, this year we had a big case, biodiagnostics laboratory, a clinical laboratory, that was involved in what the government alleged were disguised kickbacks to referring physicians, payment of lease fees for space in the physician offices, payment of collection fees to physicians. These were all papered with documents that looked appropriate. They looked like on paper arm's length leases, arm's length collection fee agreements. But the government alleged that these were unnecessary, that the payments were excessive, and that the payments were really to induce referrals. Long and short of it is the sales reps and the owners of the laboratory are already in jail. 16 physicians were criminally indicted and have now settled, and they have all settled for criminal charges. I believe they've all lost their medical licenses now and obviously lost their medical practices. So this is a pretty big deal. Stemming from this and the concerns with the biodiagnostics case and others, this OIG fraud alert is basically saying, listen, there are a lot of difficulties if labs are going to be paying physicians for collection services. There may be situations where it's warranted, but in this alert, the government is outlining a lot of elements of what it would view as problematic arrangements. So if you're involved in any arrangements where there may be collection fees that you would be paying to a physician, or if you're being approached by physicians asking for collection fees or you've lost business to another provider who is paying collection fees, you may want to use this fraud alert to explain to the physicians that they are certainly equally at risk under the fraud and abuse laws if they're accepting payments, except for very limited circumstances. The second part of this fraud alert is dealing with registry payments. These are payments made to keep up clinical registries or databases or clinical studies. And certainly a lot of physicians have participated in data registries and clinical studies, particularly traditionally in the pharma area, but we see more and more labs doing this. The concern has been that from the government's perspective is that many laboratories are using these registry fees, again, as disguised kickbacks, because the physicians are getting a fee for every patient test that they order, with the understanding that the data from that patient test is going into the registry. And this has been quite a concern for the government. There was recently a settlement that the government had with Bostwick Laboratories regarding a clinical study in which the government alleged that the design of the study really constituted a kickback in exchange for the physicians ordering the services. So if any of you are also involved in situations where you may be engaged in clinical studies or data registries where payments are made to referring clinicians for participation, be mindful that the government is concerned about these. Again, this fraud alert explains when such payments can be appropriate, but also has a list of suspect arrangements. So I throw that out there just for any of those who might be involved in such arrangements. Another issue to talk about, which is one that isn't going to be affecting you yet in California, but I expect to be growing, and those are initiatives by Medicare and other payers setting clinical guidelines that may affect frequency and other ordering patterns for pathology services. Palmetto, who had been the California Medicare carrier, Palmetto, as you know, tends to be on the forefront of new guidance that would affect pathology and laboratory services and reimbursement for those services under the Medicare program. Palmetto, in late May, last week of May, came out with new guidance dealing with ordering special stains, IHCs, for gastric biopsies, among other guidance that's come out with recently dealing with pathology and lab services. But what's important about these is, one, we may see it extend to the other MACs, the other jurisdictions, also to private payers, but I think we'll see an extension of this type of activity. What Palmetto was saying was for Medicare payment in any of the Palmetto Medicare jurisdictions, special stains for gastric biopsies have to be ordered by the pathologist. So, you know, it's not going to work for the GI to have a standing order to order stains. They're going to have to be ordered by the pathologist. In addition, Palmetto said that no more than 20% of gastric biopsies should have stains performed. Basically, Palmetto is looking at data. It said it looked at data from the industry and determined that 20% is really a threshold. And if any pathology practice or laboratory is doing a rate of special stains that's greater than 20% on gastric biopsies, then, and these are the words of the memorandum from Palmetto, the carrier, will take further action. Unfortunately, it didn't say what that further action is. One option could be it may just mean the practice is subject to some investigation or audit, where Palmetto will go and try to determine with their medical necessity. Maybe it means that they would try to recoup payment on anything over 20%. Problem is, they didn't say what they were going to do other than they would consider further action with respect to the pathology practice. It's certainly troubling that we don't know what the further action is. We also don't know, based upon that guidance, whether medical necessity documentation would overcome this presumptive 20% threshold. But the real message here is I expect, and so do most observers, that we're going to see an increase in this kind of activity from the Medicare program and from private payers, where they're going to be looking at some best practice and clinical guidelines. My concern for pathologists is that other parties are going to start setting them for you, be it the Medicare program, United Healthcare, Cigna, Blue Cross. Other specialties have been much more proactive in setting clinical practice guidelines than pathologists have been. Bob, I certainly throw out, I don't know if the CSP has any subgroups or committees that may be working on development of these, but maybe something to consider so that pathologists have a much more active and proactive role in these guidelines, because I think they're coming, rather than having them established for pathologists. So just be aware that that is out there. The actions of Palmetto in looking at the special stains really leads to a bigger issue that I'm seeing increasingly with audits among our clients from Medicare and from private payers, and that's getting to the medical necessity of pathology services. I'm not seeing the questions really regarding your basic 88305, but I'm seeing a lot more audits questioning medical necessity of special stains, fish, flow, if we're looking at any what we might broadly call add-on services. And again, not just Medicare, but I'm also seeing this from private payers. In general, what I am seeing, if it's a Medicare program, typically via CERT audits, which are a type of audit that the Medicare program does, but occasionally ZPIC audits. And ZPICs are the ones where there's some suspicion of fraud or improper activity. So if you ever get a ZPIC audit, that's definitely when you want to have, a few bells and whistles going off, because usually they're looking for a problem with a ZPIC audit. A CERT tends to be a much more random audit. It doesn't necessarily mean that there's any suspicion you're doing something wrong. But they're looking for several things, and from the pathology provider or the laboratory. One, they want to see an order for the test. Well, if we're dealing with an add-on, let's say we go back to the IHC. It is very likely that the pathologist did, in fact, order the IHC. Question is, do you have an order for that IHC? Because there is no exemption in Medicare rules or in any private payer rules for there not to be an order for something a pathologist is requesting. It's the same rule as would apply to any other medical service. If a surgeon's ordering, a biopsy, if a surgeon's ordering an MRI, whatever diagnostic services are being ordered by a physician, the Medicare program and other payers do require a documentation of a physician order. Now, that can be via a requisition, your signed requisition. It could be an electronic order that might be placed into some type of LIS system if you have that capability. It can also be, any kind of documentation that you may have that is retained. My concern is when I've talked to many of my clients about this situation, and it may be that the pathologist scribbled down or called down the lab and said, yes, run the stain. There may have been notes that someone in the lab may have scribbled down on a piece of paper or maybe in the margins of something, but I don't have what Medicare would want to see as a physician order. What's important in this area, too, if I take the physician order concept further, is although the Medicare program has said that physician signatures are not required on orders for clinical laboratory services, anatomic pathology is not a clinical lab service. So if we're dealing with IHCs, for example, we're dealing with services that are not on the ClinLab fee schedule, they're on the Medicare physician fee schedule, anatomic pathology. The Medicare program actually treats those differently. They're not ClinLab services, they're considered diagnostic services in the same category as imaging services, for example, for an MRI or CAT scan. Medicare won't pay for an MRI or CAT scan, or, technically speaking, any anatomic pathology service unless there is a signature from a physician documenting the order. And this can come via something signed in the patient chart. I mean, a surgeon could certainly put in the patient chart, I am ordering this MRI, initials by the side, signed at the end of the day. That works. Or it can be a traditional signed order or signed requisition. So, or it could be electronically as well. So when you're putting together your physician pathologist orders for these additional services, make sure that you do have a signature somewhere. I think it will save you a lot of problems on audit. When I am having these audits, particularly the CERT auditors from the Medicare CERT contractors at CERT, they are asking for the signed orders. Now, oftentimes, to be honest, we don't have them. Just people haven't been signing these things. Even when you're getting work coming from surgery centers and other places, I recognize you rarely are going to have a signed order. They generally will take an attestation, which means you go back to the physician and say, he or she writes, yes, I attest I did in fact order these services that are shown on the attached spreadsheet, and they were medically necessary for my patients. And those are generally accepted. But if you can get a system in place so that you have the signed orders, it would save you that headache in the future. So the order is the first thing that these carriers and the payers are looking for when they do the audits. The second is they want documentation of the medical necessity why these were ordered. And I'm seeing this with IHCs, I'm seeing it with flow, I'm seeing it with fish, where they want to see documentation of why was this necessary, specifically for this patient. That means having a standing order for some of these makes it very difficult, because standing orders many times don't go into the kind of detail that might be needed to say why was this IHC needed for the biopsy for Jane Wood? You know, it may be much more general than that. This can be in the pathologist's interpretive report. So if you've ordered the special stain, you could certainly work language into your report explaining that, you know, what your observations were, that you ordered the stain, why you ordered it, and the third part of this is the government and the private payers want to see how were the results used. Again, from a pathologist's point of view, when obviously I'm not a physician, but when I speak to my pathology clients, I say yes, they can certainly work into the interpretive report the reason why they ordered these and how they were used in terms of the diagnosis and interpretation. So you can work that into your report. But those are the elements we need: an order, some signed order by the physician, the reason, establishing the medical necessity of why this was ordered, and some documentation that the results of the test were actually used by the ordering physician with respect to his or her services. Easy way to think about this is it's really the same as if a surgeon ordered an MRI. Government's going to want to see a signed order, they're going to want to see the reason it was ordered for medical necessity, and they're going to want to see some documentation that the physician actually reviewed the results of the MRI and took them into account in terms of the diagnosis or treatment of the patient. Really, these are not unique rules, but I haven't seen this type of audit activity against pathologists in the past. One thing I will mention here too, and that is a disturbing incident I had recently, still working through, but it points to the importance of medical necessity. I have a client who has a pathologist, has a genetic laboratory, does a lot of molecular testing and other types of testing, went through a Medicare audit. It was one of these ZPIC audits where they're particularly harsh and looking for things to find wrong in essence. And they pulled records from the ordering physicians. So we had testing, molecular testing ordered. They pulled records of ordering physicians, primarily because one patient complained. There was a patient who complained. She got the bill for the copayment on the coinsurance amount and said, well, I didn't know my physician was ordering this test. You know, one can certainly understand that many Medicare beneficiaries would not understand that their physicians have ordered a particular test. But so she called and complained about it, and that's what opened up the inquiry. Well, apparently the ordering physician had not well documented in the patient chart why he had ordered this test. I mean, he certainly documented that he ordered it, but didn't document the medical necessity for this patient. So the ZPIC did go back and say, well, you know, obviously the lab will have to repay the dollar amount. This is not a covered service because there's no documentation of medical necessity from the ordering clinician. Furthermore, the ZPIC triggered a very, very unusual Medicare rule. I've never seen it used before in this sense, and we're certainly getting the national associations involved in this. Medicare does have a rule that says if they suspect that there is a significant overpayment or some other activity that could be fraudulent, they can actually suspend your payments. So this laboratory has its Medicare payments suspended. The really problematic part is there are no appeal rights under this suspension. Medicare is only required to look into the situation again after 18 months. So they can't let the suspension go more than 18 months without re-reviewing it. Obviously, we're working on a lot of different angles to try to address this issue. But I now have a situation where because an ordering clinician did not adequately document medical necessity for what he ordered from the pathology laboratory, I now have the pathology laboratory's Medicare payments suspended. To me, that's a huge leap in logic for any Medicare contractor to do, and I've never seen it before. But I want to alert you to it because when you are speaking with clinicians who are ordering tests, particularly if you're dealing in an area of testing that may not be as recognized, it may be some molecular testing, there may be maybe a little bit more on the borderline of whether or not it's really medically necessary, or it might be more of a screening type of test. It's going to be very critical to talk to the clinicians and ask them to be as thorough as they can in documenting medical necessity. Because if it's not in their records, you're left holding the payment bag if Medicare or another payer comes back to recoup payment on this. I'll leave the medical necessity topic for a while and just move briefly to a proficiency testing update. Many of you may be aware that we had, for a number of years, some very disturbing cases where CMS was taking action to revoke the CLIA certificates of laboratories where there had been inadvertent proficiency testing violations. Many of these dealt with HIV testing, where the protocol within the laboratory for a positive result was to send it out for confirmatory testing to another laboratory. The problems would arise because a tech would get in the proficiency testing sample, knew that the proficiency testing sample had to be treated in the same manner as a patient specimen, went to the protocols and said, well, here's the protocol. You know, if it's positive, it needs to be sent out for confirmatory testing. That is a proficiency testing violation, even though there was a lot of confusion over this. In response, thanks to the efforts of, quite a few federal legislators and national associations, we have what's called the TEST Act. And the TEST Act was signed by the president, and it basically was giving CMS more latitude. The CMS felt like it had to throw the baby out with the bathwater in these cases. It gives CMS more latitude to take a more flexible approach with respect to these violations. CMS did publish and propose regulations to implement the TEST Act, and those regulations actually go into effect next week on July 1st. What I want to point out, though, is I think a lot of people, myself included, thought that once the TEST Act was passed, we'd see CMS really take a kinder, gentler approach to these proficiency testing violations. And in fact, that's not what we've seen. Hopefully, once the regulations go into effect next week, we'll see a little bit of change in attitude. But even since the TEST Act was passed, I've been involved with quite a number of these proficiency testing violations. I've had 4 or 5 of them since the TEST Act was passed, where CMS was doing the standard, which is we're going to revoke your CLIA certificate, the medical director isn't going to be able to own or operate a lab for 2 years. Now, most of those have ended up with satisfactory settlements. One of them did not. One of them, the CLIA certificate actually was lost, but it happened to be a hospital that was being sold anyway, so it was not as critical. So be aware, make sure that if you are the director of a laboratory, be it a hospital lab or your own independent lab, really make sure everyone who's involved in any proficiency testing really understands the rules, is very mindful of this. CMS is still taking a pretty strict approach to these proficiency testing violations. And because of all the attention that the issue has gotten, I have the sense from at least some of the CMS regional offices, I think luckily in California you have a more reasonable office in San Francisco than in some other regions of the country, but I have the sense that some of the CMS regional offices are taking the position of, with all the press on this, shouldn't the labs know by now? We're really not going to take an excuse that the lab techs didn't understand the rules. And they're expecting that the laboratory directors spend a lot more time reminding people of the proficiency testing rules. Next issue I wanted to move to, and sort of moving from the issue of directorship of labs and proficiency testing, is talking about medical directorships just in general. We're seeing a lot more of our pathology clients who are being approached by physician offices who have their in-house labs, be it a histology lab, a clinical lab, or increasingly toxicology labs. And the referring physicians who have these in-house labs, these are labs they have within their own offices to fit within the Stark Law. The lab is owned solely by their practice, only for their own patient work, but they need a pathologist to be the director of a high complexity laboratory. And so I have a lot more of my clients who are now calling up saying, hey, we've been offered this directorship by this medical group, somebody I know, or someone who might be on staff of the hospital, and can you make a contract for it? And what I'm finding when I'm speaking with a lot of the pathologists is some of them really don't appreciate the risks, the liability, the issues that can arise in being the director of a laboratory. Remember, under CLIA, under the California laboratory regulations, if you're the director of a laboratory, you're the captain of the ship. you're held responsible for whatever may go wrong. And the problem is, if you're dealing with many physician offices where they are not pathologists, there are other specialties, you don't have people who may have a lot of experience in laboratory testing, particularly if they're looking at running a high complexity laboratory. For much of this toxicology testing, they're increasingly moving to quantitative, high complexity testing. There are obviously lots of rules and things that have to be followed, a lot of training of personnel, and I see a lot of corners being cut. To the extent the laboratory is not operating in accordance with CLIA and California regulations for either a moderate or high complexity laboratory, whatever their certification happens to be, as the medical director, even if you weren't there, even if you didn't know about it, you're held responsible. And the penalties that can be assessed can also be assessed against you. If the laboratory certificate, license, or CLIA certificate of the laboratory or the practice is revoked as a result, that can also have implications by meaning that you could be precluded from owning or operating, meaning being the director of a laboratory, for up to 2 years. So you really want to be mindful when you're asked to be a director of any laboratory. Make sure you have, one, a comfort level with the attention to compliance, the actual operations, the quality of the operations. Also, make sure you spend the time to actually make sure things are being done correctly, because otherwise you do have liability for that. And speaking about the regulatory liability, you have the malpractice liability as well. If there's any patient harm as a result of inaccurate testing being done, problems within the laboratory director often is named in the lawsuit. So you certainly, from that perspective, want to make sure that you've done things and done your duty as the director. It's important in these arrangements that you confirm with your malpractice insurer that you have coverage for these director duties, particularly if you're ever named in a lawsuit. Many times when we call and speak with the malpractice insurers, we find out that when physicians are serving when pathologists are serving as directors for laboratories of other physician practices, it may fall within a gap in coverage. The malpractice coverage may not extend to that arrangement, so the pathologist may find himself or herself bare without malpractice coverage. So it's also critical to make sure that you have appropriate insurance coverage. And finally, because you do have a referral relationship usually with any clinician who's asking you to be a director of his or her laboratory or the group's laboratory, you do need to have a written agreement for those services. You have a compensation arrangement now between referral parties. So we have to comply with the Stark Law, which means a written agreement that's describing the services. You need to be paid fair market value for your director services. It's not something you can be providing for free so that they send you work. You need to be paid for these director services a reasonable amount, with a term of at least 1 year. It needs to be signed by the parties. Certainly things that your legal counsel could assist you with in putting together. Moving to the next topic, I want to talk about electronic health records and interfaces, and particularly some recent OIG guidance dealing with EHRs, and in particular the Athena system, or the Athena methodology of assessing payments to laboratory and pathology providers. I think, as most of you know, the Safe Harbor and the Stark exception for EHR donations closed this year, so that pathology providers and laboratories can no longer donate up to 85% of EHR costs to a referral source. And most people would say that's a good thing. I know lots of pathology providers and laboratories felt as though they were being extorted to make these payments. However, you could continue to make payments towards interfaces that are used to connect your practice or laboratory to a client, as long as that interface is used only to transmit orders or results between your practice or lab and the client. If the interface has other uses, such as connecting to an imaging center or connecting to the hospital, the practice would have to pay for that portion of the use. And we do have an opinion from the OIG from, I guess now it's about 18 months ago, that is blessing this type of payment. But what's important is the only thing that's protected is payment for the interface, not for the EHR, and not for maintenance on EHRs. I'm getting increasing questions. I'm not quite sure where they're coming from, but I've gotten a flurry of questions within the last couple of weeks from people saying, we've heard, or our physician clients are telling us they've heard that it's still okay for laboratories to make payments on the maintenance, or make payment on just the EHR maintenance, which isn't accurate. You can't make further payment on the maintenance of any EHR. The Athena Health is an interesting situation, and it's not the only EHR that has this system, but I bring it out because it's caused the new OIG opinion on this has caused a lot of confusion. Athena has an EHR, and the way it had been set up, and Athena did get an advisory opinion from the OIG a couple of years ago on the system. The doctor, well, let's just say it's a dermatologist who gets the Athena system for the EHR. The dermatologist would have to pay Athena a transmission fee of $1 every time he or she places a lab order through the Athena system. So there's a $1 transmission order fee that would have to be paid, unless if the doctor sent the lab work or the pathology work to a pathology or laboratory provider who had a contract with Athena to be part of, basically a participating provider with Athena's network, then the doctor would not owe the $1. The doctor would save the fee. What Athena would do is then, if the pathology or laboratory provider was participating with Athena, then that pathology or laboratory provider contractually agreed to pick up the $1 charge. So basically we're talking about a transfer of a $1 charge that the doctor owed, and that would be transferred for the pathology provider or laboratory provider to pick up that $1 charge, if they were participating. The doctor could always send to a non-participating lab, but he would just owe the $1 charge. Well, Athena did ask for an OIG advisory opinion on this a couple of years ago, and the OIG wrote, well, we just don't think $1 is going to be enough to influence any physician's decision in terms of where to refer work, so we don't see this as a problem. And I think anyone who read that opinion, was a bit floored, saying, what was the OIG smoking? I mean, of course, we're not talking about $1. We're talking about $1 times however many tests the practice is ordering over the course of a year, and these become real substantial dollars and do, in fact, significantly impact the physician's decision where to send the pathology and laboratory work. Clearly, they're going to send to a provider who's participating with Athena so that they pick up the cost and the physician avoids the $1 cost. Caused a lot of concerns, and a lot of laboratories felt very taken advantage of and really over the barrel that they had to sign up with Athena to pay this fee. So there was a request for a second advisory opinion, not from Athena, but from an outside party. And the OIG unusually reversed its opinion and basically said, yep, oops, we realize now that that $1 becomes quite a bit of real money when it's aggregated for all the tests that are being ordered. And because this is basically the assumption of a financial responsibility owed by the referring physician to any laboratory that receives referrals from that physician, this would be a violation of the anti-kickback law. So, and I think that's the right opinion. But here's what's happening in the marketplace, and there's reason to bring this up. One, if you have any contract with Athena, I've certainly spoken with Athena counsel on this a fair amount, and Athena is working to reform all of its contracts and make sure that its paper is right. And I expect that they tell me that should all be in order by the fall. But in the meantime, unfortunately, this is not a situation where the laboratories are now going to avoid being hit with this $1 charge. Athena is basically removing any $1 charge from the physicians, and the laboratories are going to be paying not a $1 order fee, but a $1 transmission fee for the privilege of sending your results over the Athena interface to the physician. And we see other EMR companies that are also doing this. So in essence, they're charging the laboratories on a per test or per transmission fee for the privilege of using the interface, which usually the labs have paid for to begin with, of transmitting their results to the physician. Unfortunately, I mean, yes, that legally gets by much of the issue that the OIG raised, but unfortunately it still leaves the pathologist picking up the financial bag with a lot of these expenses, which I think really are extortion by the EMR vendors, taking advantage of the situation and getting fees where I really don't think that these are reasonable fees. But that's where we are now with EHRs and interfaces. Another issue I wanted to bring up that we're seeing increasing attention paid to, that is physician and laboratory licensure. I'm not sure how many people on the phone are doing work from out of state. Many pathologists have, I think, traditionally assumed that if they were getting consultations, if they were getting work from out of state, that they would fall within a consultation exception, because pathologists aren't delivering their results generally directly to patients. They're delivering their results to surgeons or other licensed physicians in the other states. So why would they need to have a state license? We're seeing a lot more enforcement, a lot more attention in this area. What you need to be aware of is that there are 50 states, and unfortunately there is no consistency on what the rules are as to whether or not you would need a license if you are interpreting biopsies coming from out of state. A state such as West Virginia, for example, West Virginia says, sure, we have a consultation exception. It would apply up to 10 specimens a year. You do more than 10 services a year, you need a license. Many states have an exception for consultations that are irregular or infrequent, and those are common words used. So, like, well, what's irregular or infrequent? I mean, if you're getting a couple here and there and you have no idea when they're coming through the door and they just happen to land on your desk because you might be well recognized, or maybe it's someone you went through residency with who'd like your thoughts on something, that's probably going to be irregular, unusual, and for those states which have that type of exception, you'd be covered. But on the other hand, if you landed a GI client in another state, pick the state of, Delaware. If you landed a GI client in Delaware and they're sending their specimens to you regularly, the Delaware Medical Board takes the position that you need to have a medical license from Delaware. And I happen to be aware that the Delaware Medical Board has hauled out-of-state physicians before the board alleging unlicensed practice of medicine. And there the danger is, if the Delaware Medical Board says you've engaged in the unlicensed practice of medicine, that disciplinary action can be used by the California Medical Board to revoke your California medical license. You have this snowball effect that can happen. So anytime you're taking out-of-state work, I certainly urge that you spend time and really check to see what the rules are. The other thing you want to do is check with your malpractice insurer to make sure you have coverage for that out-of-state work. We've run into a few insurers who've said, we don't care what the state law says. If you don't have a license in that state and you get sued on a biopsy that came from that state, we're not going to cover you. So you need to get the license just to make sure your insurance will cover you. I've encountered one insurance company that said they will cover out-of-state work, but only up to 20% of the practice of the pathologist. If the out-of-state work exceeds 20%, then they're not going to cover it. So you do want to have some dialogue with your malpractice insurer on this. Also keep in mind that particularly if you're getting specimens where you're doing technical component processing, there are states like California which also have state laboratory licensing requirements, and they would require your lab to also have an out-of-state license in order to process those specimens. Examples would be New York, Florida, Pennsylvania, Maryland, Rhode Island. Those are examples of states that would have that kind of out-of-state laboratory licensure requirement. So something to look into, and we see more focus upon. And particularly where I see the focus is in two areas. One is aggrieved employees, people who are leaving a practice, a pathology practice, pathologists or employees. I've seen it with sales reps who are leaving labs, and if they're upset, they may try to allege or bring some type of qui tam whistleblower action or try to gain some leverage in settlement agreements by threatening to disclose the unauthorized practice of medicine via these licensure issues. The other one I'm seeing, and that is competitors who, if you're going into the state of Delaware and you're knocking out a local Delaware pathology provider, I've seen in that situation the local providers going to the state medical board to try to knock you out of the market, to say, listen, they're practicing medicine without a Delaware license, you need to go after them. So just to be aware how this comes up. The last item I wanted to talk about before we open up to general question and answer, and that's what I'll call the private payer lab model. Most of you may be aware with the in-house histology labs that GIs, urologists, hemoncs are putting in place. Under the Stark Law, the only way that a physician practice can own a laboratory and refer Medicare work to the laboratory is if that lab is owned solely by the physician practice. You can't have two physician practices owning a lab together and referring work to it that's covered under Medicare. That doesn't comply with the Stark Law. Again, it has to be owned solely by that single medical practice where the doctors are practicing, providing their professional services. We've seen a real explosion in what I'll call private payer models, where you have consultants out there who are saying, listen, here are all these doctors, whether we're looking at ClinLab, histology, I'm seeing this a lot more in the toxicology area. We know that you can only own a lab and send your government work to it, your Medicare work, your Medicaid work to it if it's owned by your practice. But you could form a lab that's just for private payer work only. Don't send any government work at all. And many of them, the side message is, you can send all your government work to us. We're your lab consultant, and we have a lab on the side. Just send your Medicare work to our lab on the side. So they're setting up these labs that are ostensibly private payer only, and the doctors are being told, oh, don't worry, you'll be fine. We don't do any Medicare work. We don't do any Medicaid work, so you don't have to worry about the fraud and abuse laws. And I have a lot of pathology clients who are losing business to these private payer models. Here's the message you want to give any physicians who may discuss with you that they're considering this private payer model if you try to stop them from going down that path to keep from losing the business. First is, and hopefully most physicians I think will recognize this, it is very difficult to screen out government patients from any type of healthcare service. I think we all know that there are patients who come in and get services and the demographic information is erroneous. Maybe a patient who has Medicare as a secondary payer and the physician doesn't have that information right away, but Medicare is a secondary payer. Maybe it's a patient who has a Medicare HMO, a Medicare Advantage plan, and the card says Humana. It looks like private insurance, but actually is a Humana Medicare Advantage plan. It can be very difficult, I would say impossible, to 100% screen out government patients over time. Here's why it's really important, because some people have said, well, don't worry, we just won't bill the government program because we'll know just not to ever submit a claim to a government program. The Stark Law is violated by billing the government program for services that were referred inappropriately, but the Stark Law is also violated another way. It's a two-part prohibition. The prohibition is on submitting the claim, but before that, the prohibition is on making the referral. So if a physician refers the patient or sends the specimen to the private payer lab and the specimen is actually from a patient who is covered by a Medicare Advantage plan or has Medicare secondary, the Stark Law has been violated, even if the service is not performed, even if the Medicare Advantage plan is not billed. So you can find yourself in a situation where, or not you obviously with pathologists on the phone, but for a referring clinician who may invest in one of these labs, that they may have Stark violations right and left simply because the referrals have been made in error. I'm aware of one of these laboratories. It was a GI histology lab that was going on in Texas, and it was started several years ago as a private payer model, so you had lots of GI groups who were investing in it. I was told several months ago that it had closed its doors or was transferring its business. And I was told from several different sources in the Houston area that the reason is they had so much government work that was inadvertently slipping through to the laboratory, the decision was made that was just too risky to continue, because despite their best efforts, they really weren't able to monitor the private payer work as much as they hoped. The other reason these private payer models are very difficult, and that is in many states, including California, there are state-level fraud and abuse or fee-splitting laws that are also implicated. So even if these private payer labs, and I know that they're being promoted in California because I've certainly been hearing about them quite a bit from clients of mine in California, even if they purport to be private payer only, it's important that the referring clinicians look at state law, because state law does also impact for all payers, and most of these arrangements do implicate state law. Now, a lot of people don't think about state law because they haven't seen the enforcement there, but to a large extent we haven't seen the enforcement because we haven't seen this type of private payer model being set up in the past. And I would expect that we may start seeing some state enforcement with some of these state fraud and abuse laws if we see an expansion of these private payer laboratories. So I alert you to that because it is something that I am hearing about from my California clients, that there are companies out there promoting these private payer lab models. With that, I think we have about 10 minutes left or so. Bob and Rachel, I can open up for questions.
Sure. I was going to say too that your comments earlier about the numerical limits and some of the AP stuff that you're seeing from Palmetto is something that we worked with when they were our regional MAC. Now we're with Noridian, but there was a lot of activity on different LCDs regarding IHCs and flow, numerical limits. Dr. Jeter, who happens to be a pathologist, is with Palmetto and is very active in this area. So for those cases, be careful what you wish for in terms of having one of your own in charge, and she just happens to be very aggressive on wanting to establish these policies. And then secondly, your comment about laboratory directors' potential liability, you should be checking with your malpractice carrier, because you're right, not everybody looks at that as something they would cover under standard malpractice. So with that, if there's no one has typed any questions, but if anybody has any questions, please feel free to ask them.
We actually do have some typed-in questions, Bob.
Okay.
The first one is, any more cutbacks in reimbursement looming for 2015?
What I think is most likely is, because I know CMS is going back for another bite at the apple of this, you may recall that last year, or I guess 6 months ago or so, when CMS was coming out with the 2014 Outpatient Prospective Payment System fee schedule for hospitals, the OPPS for hospitals, CMS proposed rolling anatomic pathology technical component services into the facility fees. Now, CMS did do this for clinical lab services. So the Clin Lab service for outpatients is now rolled into the basic facility fee that the hospital is charging. But AP was saved, technical component of anatomic pathology was saved. So even though you can't bill Medicare directly for any technical component of anatomic pathology services, the hospital can bill, but the hospital still can bill separately for that and receive payment, which means when you're negotiating payment with the hospital, you know, the hospital is generally going to pay you some percentage of what Medicare is paying them. If CMS rolls this in, it's going to be a whole lot harder, I think, to get reasonable payment from hospitals, because that means hospitals are not going to be receiving any additional payment for inpatient or outpatient technical component of anatomic pathology. And even though it's not a direct payment cut under Medicare, under the physician fee schedule to pathologists, I think it will result in, for those pathologists who have labs providing technical component to hospitals, I think it's going to result in lower revenue from those technical component services. Otherwise, I think we may squeeze, I certainly welcome whatever thoughts Bob has, but I think given everything else that's happened, I think pathology otherwise will probably squeeze through 2015 without too much.
Yeah, I think other than, you know, private payers picking up on anything Medicare does in terms of lowering their fee schedules, that's a you know, frequent phenomena. I know that in California we have an ongoing assessment of the Medi-Cal program of evaluating their payment levels and gathering data on what private payers are reimbursing pathologists in California for, and all providers for that matter, for clinical laboratory services. I think the federal government is looking at just something very similar to that, collecting your top 5 payers of services and what they're paying you to evaluate Medicare levels as well. So, but other than that, I would agree.
I have another question for you. It is, certain state Medicaid plans are specific to the type of coverage offered to a patient. An example, pregnancy-only coverage or contraception. I bill for an independent lab that often sends me a requisition with diagnosis information not payable by the Medicaid plan. I have a process to send these back to the lab so they can request updated diagnosis information to identify a payable diagnosis. I've insisted on a new requisition with new doctor information and signature. The lab manager continues to write a note of updated info and cites pursue at Dr. XXX office. This lab manager states that they do not need to update the entire requisition for us, and per the COO of the referring office, what they are providing is enough. I contend that the COO of a referring office should not make the compliance decisions for the lab, considering he has no liability, but I don't have anything concrete to cite saying I need a signature for the diagnosis updates for these clinical pathology tests. Am I arguing this for no reason?
I wouldn't say you're arguing it for no reason, in that the federal government has made very clear that it expects, and private payers too, the ordering clinicians to provide the appropriate diagnostic information, even if it's not an ICD-9, at least a diagnostic descriptor that can be converted into an ICD-9 code for the testing. So if, again, that's the physician who sees the patient. So if I have documentation such as, per so-and-so at the doctor's office, in essence, I have documentation that's even worse than nothing, because now I have documentation showing it wasn't the physician who made that change or provided that information. It was someone else who was not involved in the care of the patient. I want to make sure my information is coming from the physician or clearly at the physician's direction. So I'm going to feel much better that I know that's coming from the physician, ideally with a signature. If it truly is a clinical laboratory test, I don't need to have a signed requisition, but if I'm ever audited on that, the Medicare program is going to want to see and will ask for copies of the physician's patient record to see if what the physician wrote in the patient record supports the diagnostic information that was provided to you and that you used to bill. So if we have a mismatch, if the administrative person in the physician's office is just giving you a code to get you off their back and everyone's happy, and that's not matching what's in the patient record, one, likely you're going to have to repay the dollar amounts, but two, you could have a payer start to get concerned about some type of fraudulent activity here. The other thing to keep in mind is you do have a very difficult situation, because if truly the ICD-9 code does not support payment, the government does not want the laboratory to be fishing and directing physicians to reimbursable codes if those are not the most appropriate codes. So if the physician's ordering something from you and the most appropriate ICD-9 is not a payable one, then in that case, an ABN should be obtained from the patient, and the patient should be responsible for it, because you do bear risk if you're going back to the physician asking him to change it to a reimbursable code if that's not an appropriate code. But it's a difficult situation, because you're really in the position of not knowing what an appropriate code is, or knowing if someone just checked a box which might not have been appropriate.
There are a couple more questions. Please comment on supplying Spira or Spira brush to clients.
Sure. We have a CMS advisory opinion on this. There are two types of advisory opinions. The Office of the Inspector General writes advisory opinions on the anti-kickback law. The Centers for Medicare and Medicaid Services writes advisory opinions on the Stark law. The Office of the Inspector General had received requests for an advisory opinion on providing the Spira brush. I was one of the requesters. I don't know who the other requester was. I know in my conversations with the OIG, when we requested, can we provide a Spira brush without charge or not, the OIG said, we are concerned about the practice of providing Spira brush without charge. They had concerns that it was being given to induce referrals. But the concern the OIG had is they write opinions about the anti-kickback law. Well, there's an important difference between the Stark law and the anti-kickback law. For the anti-kickback law, you have to have an improper intent. You know, it's very intent-based. It's really hard to give a blanket statement that something's improper. The Stark law, on the other hand, is an absolute prohibition. If you implicate the Stark law and you don't fall within an exception, then both parties are in violation of it. It's like no ifs, ands, or buts. It's black and white, no shades of gray, whereas there are lots of shades of gray under the anti-kickback law. So interestingly, the OIG asked me and asked this other party, would you mind if we bumped your opinion, or would you mind resubmitting your request for this opinion to CMS? Because we've already talked to the folks at CMS and we think they would be interested in it, and we think they would issue a much stronger opinion that would really kill the practice of providing the spiral brush without charge and not give loopholes that people, or the impression of loopholes that people could use. So I submitted mine, other requesters submitted theirs, and the OIG did issue, they ended up issuing only one opinion because apparently both requests were pretty much identical. And the opinion basically is saying under the Stark law, providing the brush without charge does constitute remuneration under the Stark law. And what that means in essence is you now have a prohibited remuneration and there's no exception that falls within, likely. You know, they certainly didn't point out any exception they thought fell within. So that means neither the physician would be able to accept the spiral brush nor would a lab be able to give the spiral brush if it is a relationship where there are any Medicare or Medicaid referrals between the parties.
Well, we are just about out of time, but there are 3 more questions. I think what I'll do, Jane, is I'll get these questions to you along with who asked them, and maybe you could go ahead and answer them.
Sure, I can do that. I can send an email. Mm-hmm.
Perfect. I will go ahead and do that. Bob, I'll turn it over to you to finish it up.
Great. Jane, thank you very much as always for your elaboration on all these issues, very timely, obviously with the OIG opinion this morning, but also just with a general background and knowledge about all these different issues that face pathologists. So with that, I thank you. I thank the participants for joining us today. If there are suggestions for other webinar topics, always like to hear them. So if anybody on the phone has some ideas about other possible speakers or topics, please let me know. And I wish you all a good day. Thank you.